What's up, Team Tobias? What's up, Chicago? You see that? You join us, you get a random shout out. Might be your city, might be your name. I'm here with Jackie Lipton and Ann Rose. Kelly Dykesterhouse, I got her name right, is off today. Super excited to talk about what we're going to talk about.
Because I'm a legal nerd. And I'm going to just do merchandising. I'm just going to flash my book, Law and Authors, a legal handbook for writers, because not that everyone should. Oh, you have one too. That's very cool. Thank you for supporting my book. But I just felt the need for us to talk about some common legal misapprehensions that people have and that I totally understand why they have them. There's often not the information available that you need until it's too late and you've agreed to something. So we thought we'd talk about some of that stuff today. There's actually two stages to contracting. There's the deal memo stage where you agree the main commercial terms like the advance, the royalties, the subright splits, which we can talk about in a minute. And then there's the formal contract, which is the big document that has everything in it. And I think what a lot of people don't understand is that both of those stages of the agreement with the publisher are legally binding. So that if you're working with an agent, it's usually not such a big deal because the agent will understand that. But I have a lot of consulting clients who come to me, and I get it because people know they need to talk to a lawyer or a contracts person at some point before they sign the contract, but they don't understand that talking to someone after they agreed the deal memo and before they sign the contract is a problem. You know, so often someone will come to me and say, I don't want you to negotiate the deal memo because I don't want to pay for more time, which is, you know, perfectly understandable. I get that. But I want you to look for red flags in the contract, you know, and the red flags, a lot of those red flags were in the deal memo that you already negotiated, or there can even be red flags about should you be dealing with this publisher anyway? Like what if they're a new hybrid publisher? Not saying anything bad about new hybrid publishers, but did you think to ask about, you know, the sales track record, the marketing plan, that kind of thing? So I did want to start off there because I've had a lot of questions about it lately. And it is important to sort of get advice at the relevant time. If you're an Authors Guild member, they have a free legal service for members who can help you. You know, when I'm consulting, I often don't charge or charge a nominal amount just to look quickly at a deal memo because it doesn't take long. You know, but it is worth talking to someone at that point.
Yeah, I mean, the deal memo is part of the contract. And when I negotiate contracts, I'm sure everyone else has run into this. When you go back and say, I want this, they'll respond, oh, well, it's not in the deal memo. Ann and I were just dealing with that with a production company where I'd say, we want this. And they said, oh, well, it wasn't in the deal memo. I'm like, yeah, but it's not in the deal memo. You didn't bring it up. We didn't bring it up. We're addressing it now because, like you said, the deal memo is binding. And the issue is when authors generally don't know this, they get the deal memo and then they decide they want an agent. We come in and then the publisher says, oh, well, we already agreed to the deal memo, so our hands are behind our backs.
And, you know, we can't do anything. Sorry, Ann.
No, I was just about to say that. And then authors don't understand, like, well, why can't you get me a bigger advance? Why can't you get me a better royalty split? Why, you know, they don't generally think about asking for certain things like escalators and those types of things at the deal memo stage. And then there's nothing we can do with it at that point. So they just don't.
Because they agreed to it.
Correct.
And it's a pain in the ass because, you know, they, like what happened with Ann and I, they will purposely not address certain things in the deal memo. So they can say later, oh, well, it wasn't in the deal memo. And some deal memos I had over the phone.
Yep.
And so I'm smart enough to say I'm emailing this, memorializing it, putting it in an email because it's not memorialized. On the phone means nothing.
Although legally it's binding. If everyone agrees, you can have an oral agreement, which is why you should do what Lane said and say, okay, this isn't the thing we're agreeing. We're memorializing it in writing and agreeing to it in our email exchange.
Yes.
You know, because one of the things is you don't know what you don't know. And a lot of things that are often left out of deal memos are things like, is there an option on the contract? Do they want you to have first right of refusal on your second book? If so, is that narrowed to the same genre as the first book? Is there a time limit that they get, that's something that not everyone immediately puts in a deal memo. You sort of want to know that kind of thing up front.
And this isn't to knock newer agents, because I was a newer agent who did this. On a deal memo, you don't think to put certain things. Like for film, and I know we're publishing agents, we talk about books, but I'm just thinking about this because Ann and I went through it. You don't think to put set visits or premiere tickets, just like newer agents may not think to put bonuses, milestone bonuses, or like Ann was saying, escalators. So, I mean, it's very important to have an agent at the deal memo stage so you don't agree to something not knowing what you're agreeing to.
And I'm assuming if we're talking to people largely who are at that point where they're doing some of their own deals and looking for an agent, should we define bonuses and escalators for folks who don't know?
So escalators are what kick in that will help raise your percentage after you hit a certain sales number. So we'll say, after you sell X amount of copies, you'll go from this percentage to this percentage in royalty rates. That's the most simplistic way that I can think of putting it.
And bonuses can be lots of things. So it will be that the publisher will pay you additional money, say for winning certain awards, or for being on the bestseller list for a certain amount of weeks, or for earning out your advance within a certain amount of time. You also want to, with bonuses, look at, is it extra money you're getting, which often it isn't these days, or is it a additional bonus against your advance that simply helps you pay off the advance more quickly?
Yeah, and I've dealt with that in contracts, and I don't really think it's a bonus. I mean, I think it's an extra advance, which is cool, but I mean, it's not free money, which is what, for me, a bonus is supposed to be. And I understand publishers are businesses and that's how it operates, and beggars can't be choosers, which isn't necessarily true either, but I'm going on a tangent. I want to talk about morals clauses, because that's the question I get asked by clients the most. What the hell is a morals clause? Jackie.
And actually, I want to just distinguish between a morals clause and a moral rights clause, because people get the two confused. In the United States, in North America, we don't do much with what we call moral rights clauses, because we don't really have those rights in publishing. We do in art and architecture, but not in publishing. But if you're dealing with, say, a British publisher, there will be a moral rights clause, and that is something about attribution, like whose name has to be on the book, and integrity, what people can do with your work without your consent. That is not what a morals clause is. A morals clause has to do with the way the author behaves and whether the author might do something scandalous or offensive or demeaning that would bring disrepute to the publisher or to the book, or would negatively impact sales. These clauses came originally from Hollywood in the 1920s, when you had dudes like Charlie Chaplin who were doing lots of things with young women, etc. They then became something that found their way into all sorts of contracts, sports contracts, all sorts of entertainment contracts, and around 2017, 2018, they found their way into publishing contracts. And because they don't come from publishing, we've had a difficult time figuring out how to draft them and what we're really trying to protect against. So when they first came out, when publishers first started using them, it was around the time of the Me Too movement in Hollywood, and publishers were like, gee, we better do that, make sure that our authors aren't doing anything terrible that would hurt the sale of the books. And a lot of agents at that point were saying things like, well, this is just giving the publisher another tool to cancel a book it doesn't want to publish, to come up with an excuse based on something minimal to cancel publication of the book, which may be true in some cases. And there's sort of legitimate arguments on both sides. But the question is the drafting, like, how do you draft it? And I think what I typically do as an agent is try, if we can't get rid of the clause altogether and say, really, there's very little evidence that what people do in their private lives impacts the sale of books. To the extent that publishers are worried about it, we try and include wording that says that would negatively impact the sale of the book, or that would actually damage the publisher's reputation. We try also to say, if this behavior is worrying, it is behavior out of the ordinary for the author. So if the author is known for blue language or something, and that's why the publisher has signed them. They can't then cancel the book because the author says something completely in character, which was why they bought the book in the first place. It has to be like a change. The author has to have done something egregious after signing the contract. So there are various ways you can limit that language if the publisher won't strike the clause, but there has been a lot of suspicion of them. The Authors Guild came out very quickly in the late, like before 2020, a couple of years before that, saying we just shouldn't have these clauses in publishing at all. It's just another excuse to cancel books that the publisher doesn't think will make money. But I don't know what the two of you do when you negotiate those. Like, how do you limit them if you can't strike them?
I usually, for crimes, if it says this has been alleged, and I always cut it out and say they have to be convicted of the crime. Because we're innocent until proven guilty.
There is very little evidence. I mean, it's very hard to think of a situation where an author has done something that has caused the sale of books to go down. And if that's what the publisher is concerned about, it's very hard to establish that. It may be that an author has done something that a publisher doesn't want to be associated with, and there's things like the Woody Allen situation. But, someone publishes the book and the book sells. So that's more of a, is this reflecting badly on the publisher? That's a fair enough concern. But what does the clause say? Is the clause about negatively affecting sales, or is the clause about bringing the publisher into disrepute, in which case they probably have a sense of who the person is and what they're writing, in most cases, before they published, or they should know that.
We were talking earlier before, right before we were ending our staff meeting and before we got on this, about song lyrics in books. This comes up a lot. This comes up a lot with new writers. It comes up with established writers. But I think it's really good to get on the record here on, what can authors use in regards to song lyrics. Can they use anything at all, Jackie?
Let me put it this way. This is going to go down a fair use rabbit hole fairly quickly. So if the song lyrics, and this goes for poetry, lines of poetry or whatever that someone else has written, if they are still within their copyright terms, so we're not talking about what Shakespeare wrote that's in the public domain. If you have song lyrics or poetry lyrics or lines of someone else's text that are still, within the author's life plus 70 years, which is the copyright term, then copyright law is this weird little thing that is what we call a strict liability tort. And what that means, it doesn't mean cake. It means a civil wrong, not a criminal wrong, a civil wrong, like negligence or defamation. But unlike a lot of those torts, copyright law is strict liability, which means it doesn't matter what your mental state was when you do it. If you copy or distribute someone else's work without permission, that's on its face a copyright infringement. It doesn't matter if you meant to flatter the author or if you're a big fan or you didn't intend to hurt anyone. That's not how copyright law works, right? So the act of copying anything from someone else arguably is a copyright infringement. There are a few little things like the de minimis defense or functionality, but I'm not going to go into that. So where we really end up with copying song lyrics and poems and whatever is usually the fair use defense. It's usually what you're saying is, yeah, I copied it, but I really didn't copy that much and it didn't commercially damage the copyright holder, and there wasn't a licensing market for it. So we have these four fair use factors: the purpose and character of the use, the nature of the original work, the amount taken, and the impact on the market for the original work. We don't have a clear answer about, how much you can copy before it's not a fair use. It's a case-by-case thing. That is a feature, not a bug, of the American copyright law system, because it's meant to be applied flexibly as new situations arise, unlike some other countries which have more cabined fair dealing defenses. So what it actually comes down to in most cases is just the risk appetite of the publisher. If your publisher is prepared to say, yeah, you just used 2 lines of this song and it's clearly fair use, and if anyone ever complains about it, we're just going to say it's fair use, you're probably fine.
But don't most publishing contracts have it in there that the author is responsible for the content of the novel?
Exactly. Because And I'm thinking, some academic publishers might be fine with it. Commercial publishers, by and large, have a clause in their contract saying if you infringe someone else's rights, including their copyright, you're liable, as Anne says. That is because publishers are risk averse. They don't want to take the risk, because if a publisher were to say, oh, yeah, that's clearly fair use, we're not going to worry about that, and the copyright holder sues them, that can be worth a lot of money. And even going to court is a lot of time. It's a big pain in the butt. You might have to fight off a preliminary injunction that says you have to remove the books from the shelves until the thing is sorted out. You don't want to deal with that. So that's why, regardless of whether you think you are making a fair use, and you may well be making a fair use, most publishers are going to say contractually, the risk is on you. So if you want to defend it as fair use, that's fine, but you're liable. So I think that's where all the confusion comes from, that we don't have a law that says, oh yeah, if you do this much, it's okay. Our law doesn't work that way. The laws in some other countries do, but American law doesn't. And this is where people get confused, because I know there used to be a law or guideline in Australia that said you could use this much and it would be fine of someone else's work. So, I do notice that some song lyrics are used in some people's books, and there are often copyright permissions in there. I have in my book, look, I'll just talk my book a bit more, but I copied in the final chapters, I was talking about fair use, and I copied some artwork that belongs to the Associated Press. Yes, okay, let's put Starbucks away. But this belongs to Shepard Fairey and the Associated Press. I have permission. My publisher said, we are not going to take a risk. If you want to use that imagery, you need permission. I actually wanted to use the Naked Gun 33 1/3 poster and the Demi Moore Vanity Fair cover to demonstrate fair use. And I approached Paramount and Annie Leibovitz's lawyer for permission. And Annie Leibovitz's lawyer said, oh, she's not going to want a little grey, black and white thumbnail of her artwork. And Paramount refused to answer my email or just ignored me. So those are not in the book. And they would clearly be fair use. I can tell you, they're black and white. They're for illustrative purposes. They're barely commercial. But my publisher isn't going to take that risk, and I don't want to take that risk.
Yeah, I had a situation where a client wanted to add song lyrics. They actually worked with the editor, and they added song lyrics. And then I saw a version of the book, and I was like, are you sure you want to do this? And they were like, well, the editor said it was okay. I was like, yes, but your contract says that you are liable for the content of your book. So I mean, it's up to you, but if you get sued, you're getting sued, not your publisher. So yeah, we had to have a conversation.
And
I have a question, Jackie.
Go ahead.
I notice in every Stephen King book I read, he always provides the copyright of song lyrics on the copyright page of his book. Obviously, the permissions, whatnot. Do you think just putting those mitigates the risk, or is he actually out there writing saying, hey, can I use these lyrics?
I'm sure he's writing and saying, hey, can I use these lyrics? Then he gets a license to use them. And a term of the license is that you will provide the copyright attribution which is what I did in my book. This is where people get so confused, and this is why I stress that copyright is strict liability. The fact that you put attribution to the lyrics, that's irrelevant to copyright infringement. That's moral rights. That's the thing we don't really have in US law as related to songs and texts. That's the right of attribution. We don't have that in our copyright law except a very tiny bit for art and architecture. So that is most likely a contractual license by the copyright holder that said, yes, you can use our lyrics, please attach a copyright notice. But that said, just not to scare a whole lot of authors, it's not always the case you have to pay a lot of money or any money for a permission. So my Obama Hope poster in my book, I think the Shepard Fairey didn't want any money. He just wanted attribution as a condition of the license. And the Associated Press, I think just you pay them a standard like $90 or $100.
I think too, it's good to mention, because we're talking about specifically about lyrics, but song titles, they are not copyrighted.
They are not copyrighted.
So that means, yes, authors, you can use a title, but you cannot use the lyrics. So now, here's one for you, Jackie. What if the title is also a lyric in the song?
Ooh, good question.
Yeah, I mean, I think it really depends on how you're using it, because if you are referring to a title, it's pretty obvious that it's a title. If you're quoting a lyric. I keep thinking of the Barbie girl case where Mattel sued Aqua for, it's a title case. The case is about the title Barbie girl, but that line is also all throughout the song, and the lyrics are reproduced at the end of the judicial decision in that case in the Ninth Circuit. But I think it's usually fairly clear from context if someone is actually humming, singing a song versus referring to listening to John Lennon on the radio singing about yesterday. You know, okay, you're either paraphrasing what the song is about or referring to the title. So I think it's usually fairly clear. Have we got parting shots or should we wrap it up?
Yes. And why don't you take us out?
You always ask me to take you out. I am not good at this. All right. Well, if you have enjoyed listening to our conversation today, please like, subscribe, and leave us a comment here below on some topics you would love us to touch upon here on the Literary Lens podcast. Make sure you go and buy a copy of Jackie's book, which is called Law and Authors, a Legal Handbook for Writers. And also, while you're at it, you can always pre-order a copy of my book, The Seemingly Impossible Love Life of Amanda Dean. That's coming out in September. So that's it. Come back, join us again, like, subscribe, tell your friend, leave a comment. We'll see you again.